These 5 things could cause your estate plan to fail. You spent thousands of dollars on documents, you've signed everything, witnesses, notaries, it's in a sexy binder on your top shelf, but it still doesn't work. Let's talk about how to avoid those 5 big mistakes that could blow up your estate plan. Today, we're going to break down the 5 biggest reasons estate plans fail and make sure that yours doesn't. Mistake number 1, your trust wasn't funded. Did you establish a revocable living trust? If you're like many people in Middle America, you've established this document. However, I can confidently say that less than 10% of the trust I've reviewed will actually work. Why? Because there is this notion of trust funding that has to occur after you establish the document. After everything's been signed and witnessed, that next step is often missed. This is the step of taking ownership of bank accounts and real estate deeds and investment portfolios and changing them to reflect the ownership, the title of the revocable trust. Now, if you didn't take that step, then your trust is likely not considered trust funded. A trust only works when it actually takes ownership of the asset. So the bank account, the real estate deeds, the investment portfolios, they have to be owned by the trust. That is what you call trust funding. Now, one other element for trust funding for many people is where they have assets such as annuities, life insurance, and retirement accounts, where they may name the beneficiary of those assets also the trust. Most trusts that we review, they'll fail. They will not work the way the client thinks they will work. And it all comes down to a lack of trust funding. So be a part of the 10% club. Have that trust funded, because easily 90% of those trusts we review, they'll fail, they aren't funded, and they won't work the way you intended them to work. Mistake number 2, we have to acknowledge that title and beneficiaries supersede everything. It doesn't matter what your will says, doesn't matter who the attorney was that drafted it, it doesn't matter. Beneficiaries always win. Say it with me. Always win. Beneficiaries supersede everything. The Wall Street Journal reported on a couple many years ago. The husband was a truck driver. The wife, she was an educator. And they have been saving away in her teacher's retirement account. He, as a truck driver, didn't have access at the time to something like an IRA or a 401k. So that's why they deferred everything to her retirement account. They had their retirement bucket list of all of the adventures and all of the things that they were going to do when they decided to retire. As retirement approached, they started getting all their paperwork together, pension, Social Security, all of the things. But then tragedy hit. The wife unexpectedly, she passed away. Well, obviously, there was a ton of grief and a lot of upsetness in that situation. The husband went to make a claim on the retirement account. When he did so, the custodian said, "We're sorry, sir, we can't talk to you." He said, "Well, what do you mean? I'm my wife's beneficiary." "Sorry, sir, but you're not. I don't think you understand. We just redid our wills a few months ago, and I am her named beneficiary." "Sir, I'm sorry, but you are not named on her retirement account." Well, after further investigation, what was discovered was that the wife, years before she even knew her husband, had put her sister down as the beneficiary of her retirement account. They had been married for a long, long time, and she never thought to update it. The court upheld, after being challenged on 2 different occasions, that beneficiaries always win. The sister inherited about $1 million in that teacher's retirement account, and the husband got nothing. 0. He challenged it. He lost. The takeaway here is that beneficiaries always win. For our audience today, here's your homework. Contact all of your custodians you do business with. Who has your IRA? Who has your 401k? Who has your 403b? Who has your 457 plan? Who has the annuity? Who has the life insurance? They all have beneficiary forms. Who is named? Make sure that who you've named matches up with who you've listed your will and your trust. If they don't match, you might want to do a change of beneficiary form. 5-star tip. You may find that you have an account where no beneficiary is named at all. You certainly don't want this to unnecessarily go through probate because you didn't have a named beneficiary. Mistake number 3. You have a financial power of attorney that's gone stale. What do you mean, Nick? That's weird. I know. Have you ever had homemade bread? How long does it last if you don't eat it all? Obviously, I wouldn't know. I always eat it all. But rumor has it, it lasts about 3 days, maybe 2. And then it gets moldy and stale. Well, that basically means it's no good anymore. That's what happens to powers of attorney. As they age, they have a lower and lower probability that they'll work. Here's an example. My dad is a crazy adventurer. And the older he gets, the more adventures he goes on, and I love it. One of his credos is, I want to be able to say, I'm old, I can help. So he continues to go on these amazing adventures, and one of his passions is skiing. As a matter of fact, he leaves next week to go on a great ski trip. Well, heaven forbid, but what if there is an accident and Dad is incapacitated? We bring Dad home, but he needs care, and we need to get one of those vans with a wheelchair lift. Now, I don't know what they cost today, but I know a number of years ago, they were approximately $50,000 to $60,000. So let's say that I'm Dad's power of attorney. I go to the bank. I say, Mr. or Mrs. Banker, here's the power of attorney. Dad's been in an accident. All the paperwork's right here. I need $50,000 to go get a van for Dad. Do they give me the money? Let's just say they do. They give me $50,000 for that van with a wheelchair lift for Dad. I go on my way. The next day, my sister shows up. She goes to the bank and she slides across the table a power of attorney and she says, Dad's been in an accident. I need $50,000. Then the banker says, wow, I saw your brother in yesterday. My brother? Yeah, he asked for, you didn't give him the money, did you? Well, yeah, he had the power of attorney. My dad hasn't talked to my brother in 5 years. Oops. Now, let's say that I was acting in good faith and I didn't know that Dad had updated the financial power of attorney. Who now is liable? Who's in trouble? I don't know. But can you see how that could cause a problem? It's because of instances like that that all financial institutions and insurance companies today have their own rules as to how they will accept your financial power of attorney. And one of the things that they have as criteria is how old is that document? Here's our rule of thumb. Keep that current. Every 3 to 5 years, update it with fresh signatures, fresh witnesses. Even if you're not changing anything, keep it current. Now let's do one better. Now, I know this is going to be a pain in the butt. Just trust me on this. Take your financial power of attorney and submit it to all of the different companies you do business with. The financial institutions, the insurance companies, send it to them and ask them, if there was an incapacity, would you accept this power of attorney? Now, you're going to probably get one of 3 answers. Number 1, yes, no problem. Great. Print that out, keep it with your power of attorney, and keep it stored with your legal documents. Number 2, no, we don't like how X, Y, and Z is phrased or said or laid out, etc. So then you find out if you changed that, they would accept it. So now you've got a decision to make. If you really want to work with that financial institution, you can go back to the attorney and have them change your document, or now you know the financial institution to work with. Number 3, you may find out that they say, we have our own document. Well, you know when the worst time to find that out is? After something's occurred. After incapacity, you go to use your financial power of attorney and they say, sorry, we need you to fill out this one. Well, if that person's incapacitated, it's too late. Make sure you check with all of these financial institutions and insurance companies and make sure that they will accept that power of attorney. Mistake number 4, we're coming back to the financial power of attorney. The mistake isn't just how old that document is, it's whether or not it has certain language. That language we're looking for is called durable language. What the heck is that? Durable language is what allows for the financial power of attorney to stay in force, to stay in effect in the event of your incapacity. Well, Nick, the whole reason I did the financial power of attorney in the first place was in the event I was incapacitated, somebody could handle my financial affairs. I understand. But most of the financial powers of attorney out there today, if they don't have the durable language, they end at your incapacity. There are exceptions like immediate powers of attorney, etc. At the end of the day, durable language matters. You want to make sure that's in your document. We aren't giving legal advice on this channel, and we're not telling you this is legally what you should do or what legally should be in a document. We are using best practices, giving you observations in real life where we've seen things fail. And one of the big fails we've seen with powers of attorney is they were missing durable language. Okay, guys, you've hung in there with me so far. Mistake number 5. You've moved states, but you didn't update your documents to the new state. You see, estate planning is state specific. While it all has to come into agreement with federal law, every state has their own nuances and their own laws. So my will, my trust, my powers of attorney, my healthcare documents here in Georgia might not be honored in Tennessee or in Washington or in North Carolina. They all have their own laws, and heaven forbid, but California, Texas, Louisiana, they have very different laws. So we want to make sure that we are updating our documents when we do move locations. Now, maybe that's as simple as a codicil to your will or amendments to your trust, or perhaps you have to do a restatement or a complete rebuild of your trust. I don't know, but that's why we seek wise counsel. Work with those legal professionals that they pay attention and they focus on estate planning. You don't want the local DUI attorney doing your will. So work with the experts, work with a specialist, and seek wise counsel. An estate plan isn't something you do just once and you set it and forget it and hopefully it works. Hope's not a plan. The reality is your life's going to change over time. Health changes, relationships change, economics change. You could move. There could be a fallout with a personal family member. There could be a new marriage, a new baby, and those are times to celebrate. There could be all kinds of change. It will happen. Here's the thing. If you haven't reviewed your estate plan, at least in the last 3 years, now's your time. I'm calling you out. I'm saying, please take charge. Let's be good stewards of what we've been given. And from a coach, I want to help you make the smart play. Seek the wise counsel from the people that have done it successfully over and over again. Find the experts. There are a lot of really great qualified people out there that can help you navigate important decisions. Everything from, is a trust appropriate for me? How should I change my beneficiaries? Should I reflect my trust in the title of this piece of real estate, or should it be in an LLC? These are all really important estate plan considerations. If I'm talking to you today, if I'm reading your mail, you're looking to get questions answered, you want some guidance or some coaching, check out the description below. You'll see our email. Reach out to us. We're happy to answer your questions or maybe give you just some prudent guidance. Until next time, thanks for being here and for staying coachable.
Investment advice offered through Merit Financial Group, LLC, a registered investment advisor.